A peaceful protest suddenly fractures into chaos, forcing police into rapid, high-stakes decisions that immediately trigger human rights scrutiny. To track how convention rights apply, we'll follow a 72-hour timeline. At 08 a.m., police ignored domestic abuse reports. At 14, by contrast, the right to life under Article 2 and the right to liberty under Article 5 are limited rights. Limited rights contain exhaustive, explicitly written exceptions. Your job as an analyst is to stress test the state's actions against those exact boundaries to see if their conduct remains lawful. Let's apply this to the very first node on our timeline, the ignored intelligence at 8 a.m. The core issue here is whether the state's failure to act breached its positive duties under Article 2. The rule states that Article 2 prohibits the state from taking life, but it also places a positive obligation on authorities to protect individuals whose lives are at risk from the criminal acts of a third party. Applying the legal tests established in Osman and Khalidze, a breach occurs if the authorities knew or ought to have known of a real and immediate risk to an identified individual, and then failed to take reasonable operational measures to avoid it. That brings us to 1415. The police locate the suspect and violently tackle him. Even if this force proves lethal, the rule under Article 2, Section 2 permits it, provided the force used was no more than absolutely necessary to defend a person from unlawful violence or effect a lawful arrest. But the application of this rule requires looking past the physical confrontation. In the McCann death on the rock case, the European court ruled that while the soldiers pulling the trigger did not violate Article 2, the flawed control, planning, and intelligence behind the operation did. A common mistake on exams is hyper-focusing on the physical tackle itself, while completely missing the state's invisible administrative obligations leading up to it. Furthermore, as determined in Da Silva, following the tragic shooting at Stockwell Station, Article 2 imposes a strict procedural duty on the state. Anytime the state deploys lethal force, it is legally bound to conduct an independent, prompt, and thorough investigation, regardless of whether criminal charges are ultimately filed against individual officers. Now, rewind 15 minutes to 1400, when police trapped innocent bystanders inside a containment cordon. The issue is whether this kettling tactic constitutes a deprivation of liberty under Article 5, or if it is merely a restriction of movement. This spectrum visualizes the Gazzardi rule. Courts define a deprivation of liberty by the degree and intensity of restrictions, weighing their type, duration, effects, and manner. Applying Austin, a temporary cordon averting immediate risk, when no alternative exists, is a mere restriction. Article 5 is preserved. The suspect's detention, however, is a different story. At 1500, he is placed in a cell and held for 72 straight hours. Article 5, Section 1, subsection C allows for lawful arrest, but it mandates that any deprivation of liberty follow a procedure prescribed by national law. In the UK, that procedure is the Police and Criminal Evidence Act 1984. This chart illustrates the strict PACE timeline. Police authorize an initial 24 hours. A superintendent can extend that to a hard cap of 36 hours. To hold a person up to the absolute 96-hour maximum, police must apply to a magistrate's court for a warrant. By holding our suspect for 72 hours without obtaining that judicial warrant, the police directly breached the strict parameters of PACE, rendering the detention arbitrary and the Article 5 deprivation of liberty unlawful. This extended unlawful detention leads straight into the final phase of our timeline. Suffering from severe anxiety after 72 hours in custody, the suspect confesses when police suggest he can go home if he talks. The issue becomes whether prosecutors can use this unlawfully obtained evidence at trial without automatically violating the Article 6 right to a fair hearing. European court jurisprudence, specifically Conn v. United Kingdom, dictates that Article 6 does not automatically exclude improperly obtained evidence. The court looks at whether the trial, evaluated as a whole, remained fair. However, UK domestic law imposes its own rigorous safeguards that override that flexibility. Under Section 76 of PACE, a criminal court must automatically exclude confession evidence if it was obtained by oppression or through circumstances that make the confession unreliable, such as prolonged, unauthorized detention and police coercion. Furthermore, Section 78 grants the court discretionary power to exclude any prosecution evidence if its admission would have an adverse effect on the fairness of the proceedings. Here is a crucial distinction for your analysis. Never confuse the procedural flexibility of Article 6 regarding improperly gathered evidence with the absolute boundaries of Article 3. While Article 6 permits a holistic fairness test, evidence obtained via Article 3 torture is an absolute legal wall. Pulling back from this specific 72-hour timeline, we can abstract these rules into a repeatable methodology for any human rights problem question. This flowchart illustrates the workflow. Step 1. You must verify that the claim is being brought against a public authority under Section 6 of the Human Rights Act. Simultaneously, confirm that the claimant holds legal standing as a direct victim of the breach under Section 7. Step 2. Firmly categorize the specific right in play. Is it an absolute right, like Article 3, or a limited right, like Articles 2 and 5? Step 3. If the right is limited, you have to exhaustively audit the specific codified exceptions written directly into the text of the article itself. Finally, Step 4. Layer the relevant domestic legislation, like PACE, and case law precedents on top of the convention right to test for the state's positive operational duties. Remember, testing for procedural investigative duties is a mandatory step whenever state force is deployed on the ground. Solving these problems requires moving past vague concepts of morality or broad, unanchored notions of fairness. ECHR jurisprudence functions as a structural balancing act between state authority and individual autonomy, using specific legal thresholds to determine lawfulness.